Good morning, everybody. Welcome to this meeting of the Countryside Rights of Way panel. And we'll start, please, with item number 1, which is apologies.
Good morning, Chairman. I've received apologies from Councillor Abrahams, Councillor Hudson, Councillor Pritchard and Councillor Snape.
Thank you. And just to clarify, please, I have to leave after the presentation of the S53 application because I'm a local member. Will we still have enough councillors to be quorum?
Yes, Chairman, quorum is 2.
Wonderful, thank you. Just to clarify that. And have we any declarations of interest in accordance with Standing Order 16.2? My interest is that I'm the local member for this item. No other interests. Fantastic. And we move on to item number 3, which is minutes of the meeting held on the 14th of October 2022. Are we happy with them? David? You happy with the minutes? Yeah. Okay. Thank you. Now, at this point, because I'm the local member, I will stay and listen to the presentation, and if I have any views as local member, make them then. I'll then leave the room while the application is discussed. So, who's doing this? Wonderful. Would you like to... oh, sorry, apologies. I'll read out what it is first. Item number 4, the S53 application, alleged footpath between public footpath number 11 and public bridleway 0.127 Castle Church. And David is now going to chair the meeting. Do you want to carry on then, David?
The next agenda item is first item on the agenda. So I think we're on over to you.
Thank you, Chair. Members. This is an application for an addition of a public footpath from public footpath 11 to public bridleway 0.1287 Castle Church, now in the parish of Hindley. The line of the route can be seen at Appendix B of the report. The application was submitted based on user evidence. In support of the application are 18 user evidence forms from members of the public who claim to have used the alleged route during the requisite 20-year period. User evidence needs to be considered under both statute and common law. For the application to be successful, it will have to be shown that the public have used the alleged route as of right without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that they had dedicated the route as a public right-of-way and that right-of-way had been accepted by the public. In this case, there is no evidence...
I'm sorry, could you speak a little closer to the microphone? I'm not receiving you very well.
Sorry.
Thanks very much.
In this case, there is no evidence of any physical challenge of the route prior to the application, and therefore the date of application will be used as the challenge date. And so the relevant 20-year period is from 1986 to 2006. 10 of the 18 users claim to have used the alleged route uninterrupted for the relevant 20-year period that is required under statute. The remaining 8 users claim to have accessed the alleged route during the relevant 20-year period, although not throughout its entirety. None of the users have indicated that they have used force to use the alleged route during the relevant 20-year period. For a presumption of dedication to be raised under statute, the amount of use should be enough to bring it home to the landowner that a right is being asserted over their land. In this case, the frequency of use is relatively high, and therefore it is considered that the usage would have been enough to bring it home to a landowner's attention if they were present. When considering the remaining part of the statutory test, this considers whether the landowner has taken any action to rebut the statutory presumption of dedication. Again, in this case, there is no evidence that has been provided to show that the landowner has taken any action to prevent members of the public from accessing the route. Whilst the landowner evidence indicates that gates were in place to control livestock, these were vandalised and never replaced. There were no signs or obvious measures taken to prevent the use over the land by the public for the requisite 20-year period. The user evidence also needs to be considered under common law. In this case, the user needs to prove that the owner dedicated the route, and that use does not need to be for 20 years. Often, this is evidenced by the way of notices or obstructions to prevent people accessing or using the path. Again, in this case, there is nothing to suggest any landowner has taken such steps. No overt actions appear to have been taken prior to the application being made. During this period, the route was clearly used as of right, as no challenges by any landowner were made, no signage was erected, and no obstacles were encountered. Moving on to consider the evidence submitted by the landowner. On submission of the application, the landowner at the time did respond, stating that they objected to the alleged route. The landowner did not consider the way to be public and stated that lock gates were in place to prevent trespassers. However, these gates were vandalised. As the tenant did not live at the property, it was difficult to monitor the amount of use. Stafford Grammar School then purchased the land over which the alleged route crosses in 2007. This was after the date of the application and the requisite 20-year period. They also responded at the time of the application, objecting to the alleged route, stating that access had been gained illegally by the removal of gates. Both the landowner evidence forms state that the gates were locked along the route. It is noted that if gates have been vandalised, then arguably use of the route has been with force, and therefore the statutory test would not be met, and it would be brought home to the user that their right was being challenged. However, the fact that only 2 of the 18 users refer to a lock gate, neither of those users said that this had prevented the use of the alleged route. There is not sufficient evidence to show a challenge to the members of the public using the route of an intention not to dedicate. It is not clear whether the gate was erected and locked to stop people from using the route, or whether it was solely there to protect livestock. Also, it is not clear whether the vandalism took place as a result of the people trying to access the route, or whether this was caused by antisocial behaviour. As the vandalised gates were not replaced by the landowner or tenant, it could be contended they did not maintain an intention not to dedicate the route. Following submission of the draft report, correspondence from Hindley Parish Council has been received, objecting to the alleged footpath. They have identified concerns in relation to health and safety and unsociable behaviour. This can be seen at Appendix I of the report. Further comments have also been received from the existing landowners, Stafford Grammar School. They have highlighted concerns regarding health and safety, safeguarding and antisocial behaviour over the alleged route as it crosses their school playing field. The response from Stafford Grammar School can be seen at Appendix J of the report. And whilst it is not our intention to belittle any legitimate concerns that have been raised by Hindley Parish Council or those of the existing landowner, Stafford Grammar School, the issues raised relating to concerns or questions as to health and safety, safeguarding and antisocial behaviour have to be disregarded under the law as it currently stands regarding the existence of a public right-of-way. These concerns are not a matter for the existing Section 53 application. The Highways Act 1980 provides school and education establishments with stronger rights if such use of a route is subject to safeguarding concerns. However, this will be a matter for the school to seek independent legal advice and not a matter for this panel in determining this application under Section 53 of the Wildlife and Countryside Act 1981. In terms of the legal test, the application is made under Section 53, 3CI of the Wildlife and Countryside Act 1981. Therefore, there are 2 tests to be considered. That of the balance of probabilities, whether the route subsists, or reasonable allegation, whether it can be reasonably alleged to subsist. In summary, it is evident from the user evidence that over 20-year usage of the route has taken place, and there are no clear overt actions that have come to light that would indicate a clear intention not to dedicate. The evidence shows that the route has been used by a significant number of people on a fairly regular basis. There is no clear evidence to suggest that the public were unable to use the alleged route uninterrupted for the 20-year period. It is clear from the user evidence supplied by the applicant that this route is held in strong belief that it is public, and evidence points to the fact that there has been uninterrupted use of the claimed route on foot during the period of 1986 to 2006. Overall, it is officers' opinion that when all the evidence is reviewed in totality, it is sufficient to satisfy the test of reasonable allegation. To conclude, it is officers' opinion that the evidence shows that a public right-of-way with the status of footpath, which is not currently shown on the definitive map and statement, subsists on reasonable allegation, and therefore the alleged footpath should be added to the definitive map and statement. Thank you. I'm happy to take any questions.
Can I start off? I fully understand the concerns of the grammar school, and it's a little difficult from our point of view because we're only concerned.
Sorry, you're going to have to call in. You're going to have to call in the local member first because he'll have to leave for the rest.
Sorry, I can't hear.
You'll need to bring in the local member first because he'll need to leave the room for these discussions.
To you.
Thank you. This is me as local member. First of all, I'd echo what the parish council have said, that there has been, I've been at meetings numerous times where there's been cases of antisocial behaviour along this footpath, but I totally agree, accept that this is not a reason to either pass or fail the application. Could I just ask a technical question? On the map in front of us, it does show the footpath going over the motorway or under the motorway. Now, is this the point at which there was a footpath bridge which was taken down? And if that's the case, does that mean that we're just talking about the footpath which is a dead end? Thank you.
So public footpath number 11 currently runs underneath the motorway bridge and runs down into Drumbles Wood, so that already exists running across one part of the school playing field, and that's already there. This particular alleged footpath forks off from public footpath number 11 up to the public bridleway.
Thank you, that clarifies it for me. Chairman, I'll leave the room now. Thank you.
There were two particular issues I was interested in. One is the line of the footpath. Looking at the maps, it doesn't quite show whether it goes across open playing fields or whether it's actually following a hedge line. And is the route of the footpath the obvious one through? If we're to approve it, should it actually be redirected, in which case we'd need to deal with it differently. I wasn't sure about that, and the second thing really, I fully understand the concerns of the grammar school over security, but I think it's a concerning issue that that's not a matter for us to consider, that we are simply looking at is there evidence sufficiently to be able to approve the application, and whatever the consequences of that, it's not a matter for this committee. But can you comment on the line of the footpath?
Existing footpath number 11 runs directly through the middle of a playing field. At the moment, the alleged footpath runs alongside the field edge of the footpath of the route. So it runs along the field edge of the field rather than through the centre of the field.
So it's following the most obvious route that it can follow.
Yes, it would seem from the plans that have been submitted by the users.
Okay, and what is open, I know it's not a matter for this meeting, but obviously we look at the care of children and people going on to sites where children are playing. Presumably, the grammar school have some things which they'll be able to do should we approve the application today.
So again, whilst that's not something that we can consider as part of the Section 53,
No, I understand that.
The school, under the Highways Act 1980, there are stronger rights for schools should they wish to look into that and get independent legal advice in relation to their rights with regards to public rights of way over their land.
Okay, thank you. Any comments?
Yes, thank you, Chair. Thank you for the presentation. I personally don't have any concerns about this application. I think there's been a high frequency of use. I can see there's no action being taken by the landowner not to allow walkers to use it. I've read the application, I've listened to the presentation. I think there's sufficient evidence is there, and there's a lot of it, and I feel that it's been thoroughly investigated, and I'm happy to accept the application, Chair.
You're proposing approval?
Yes.
Before us is clearly detailed at items 1 and 2 on the agenda. Are we in agreement with the recommendation that this should be made and added to the alleged right as shown on the plan? Would agree. Would agree. Thank you very much. Can we get the chairman back? Can I thank you for your report, by the way? Yeah. Chairman, we've approved the application, so it's back over to you.
Okay, thank you. Item number 5 is exclusion of the public. We have no items, I understand. So can I therefore thank the officers for their presentation, and thank Jill and David for their attendance. It has been a fairly poor attendance this morning, but even officers as well as members, there's been illness issues, so that's the situation we are in. So thank you very much, and we'll close the meeting at 10:20. Thank you.